Appeal in the matter of DG Group PLC and Royal Mail Group Ltd and DAF Trucks Limited and others.
Good morning, my lords. In this matter, I appear for DAF with Ms Mackesy and Mr Burke. For the respondents, Mr Ward appears with Mr Last and Ms Asepsiu. Just one or two brief housekeeping issues. There are confidential and non-confidential versions of the core and supplementary bundles.
Yeah.
I think I'm safe in saying there's only a very limited amount of confidential.
Very limited as far as I could see.
Yeah, and it's marked yellow. I think we can avoid it.
And I would have thought you don't need to read it.
No, absolutely. So I don't
if you
think
stick to the confidential version.
Yes, I think that's probably easier, and then we'll just steer our way around it. Just on references, I don't know if your lordships are using electronic bundles or the hard copies.
Personally, I've got both, and I will probably use both. But I sometimes find with authorities, it's quite helpful to look at one line.
Yes. So
I would use hard copies most of the time anyway.
Right. So that's helpful. The page numbers for the core and supplementary bundles are identical in the electronic and hard copy. With the authorities, they don't match up because the authorities electronically are a single bundle effectively, and obviously you've got four. I'm sorry, other way around. The pagination in the authorities bundle is continuous in the hard copy, but not in the electronics, I think, is the way around it works.
Well, if you give us tab numbers.
Yeah, so if we do tabs and references and perhaps use internal numbering for those, we'll navigate around, I think, fine. So I'm not going to provide any lengthy background introduction.
Well, I just want to raise two
Please.
points by way of. The first is just that I have to rise at 1:45 today because I have a commitment in the RCJ. But I think we could sit till 4:30, so that's not a problem, I hope. And the other thing was that I gave this case an estimate of 2.5 days. Is that still correct?
I think that is right. I will do my best to get through our grounds today. I might spill into tomorrow morning. But I think probably we had understood it had been down for an estimate of 3, but I'm sure 2.5.
Well, I checked. I thought
fit.
it was 2.5, but I noticed in the order I made it said 2.5.
Yeah, I'm sorry, I hadn't checked that, my lord, but
Well,
yeah.
we haven't had a timetable. I'm not criticising it. We haven't had a timetable, so.
No.
I'm asking that question for entirely personal reasons, which you can probably work out.
I won't even begin to speculate.
Last day of term,
yeah.
the last thing wants to be is the last one out of the building.
No, I understood completely. Well, look, we'll try and speed things along, and I'll try and get through all grounds. I'm just not going to promise I'll finish on ground 4 by the end of today.
Right. Thanks very much.
But I will skip any lengthy introduction. You'll have seen we have 4 grounds. The first 2 raise important questions of general application. The second 2 are important for the present case. The 4th does raise issues of more general importance in relation to compound interest, but they're important for the present case for the overall sums involved. You'll have seen the first ground is concerned with the legal test for proving quantum. And just to emphasise, this appeal's not on liability. It's about the tribunal's approach to the legal test for quantum and proving quantum. Over the past few years, there's been much interest and reference to the use of the...
I'm sorry.
I'm so sorry, my lord.
My opus 2 is to say it just says no session in progress.
I won't take that as a comment on my introductory remarks.
No, it's just I don't know if
I'm sorry.
I thought my clerk had got this up and running before I came into court because there's been a history of problems with.
I'm so sorry.
With this, which is probably due to my inability to operate. As opposed to anything else. Yeah, why don't you come? Just come and deal with it. I'm sure it's very simple.
I don't know if it's a connection issue. I mean, we're happy if you want one of ours. Just to roll.
No, I mean, I'm, as long as there is a transcript, I don't mind.
Yeah, there will be.
Yeah. Later, but it's just if I'm trying to follow it as you're speaking, which later in your submissions I'll need to do. So somebody needs to get it up and running
Yeah, well, if someone from Office can come along. I'm sorry.
I have the problem, I haven't been given the password, and I thought it was set up, but it's not, and I can't get in. So
Right.
maybe if someone could just invent a password for me and get me in.
I think we have a spare account, so we can give that to your lordship.
I'll say it again, I've said it before. Whoever it's directed to, whether it's Office 2 or those instructing you, I suspect it's Office 2, this is not the first time this has happened this term. It's about the third time something hasn't been right when we started. If we're having a transcript with Office 2 operating it must, and I emphasise the word must, be up and running for the judges sitting in the Court of Appeal before we come into court. You've got, God goodness knows how much time before 10:30. It's just no excuse for it, I'm afraid. None whatsoever.
I quite understand.
It disrupts the proceedings, makes the judges irritable, etc., etc., etc.
Well, I think all of those around me, and indeed I hear your lordship, and I think the message is well understood.
You were saying that the first ground, what I suggest we do is unless somebody can actually deal with it as we're going along, we'll have to have a break for the transcriber at about 11:45. If it isn't resolved by then they'll have to resolve it then.
Yes.
But if you can get somebody here soon, thank you.
Great. Well, I'll live in an old-fashioned
Your
denial
first
about the
ground is to
rolling
do with the legal
transcript.
burden for.
Yes, exactly. So, I mean, as we've seen, the concept of the broad axe has been used in some recent cases and is a weapon which this tribunal was very ready to wield. And what I'm going to explain in relation to ground one is how in doing so the tribunal failed to apply the proper legal approach to the proof of quantum. And just to emphasise, this is not an appeal seeking to impose an artificial degree of precision on the assessment of quantum. It's trying to identify what the right legal approach is, even when there is imprecision, and show that the tribunal followed the wrong approach in relation to its assessment. The second ground, which I'll come on to, concerns the proper legal approach to passing on of any putative loss. And again, it's an issue that has been canvassed in recent case law, including in the Supreme Court. But in this case, we'll explain how the majority of the tribunal adopted the wrong approach to the assessment of the relevant evidence and the legal approach, an issue which is the subject of an important dissenting opinion from the expert economist who sat on the tribunal. The third ground, it raises issues about the definitional scope of the infringement. And the fourth, as I touched on, raises issues to do with compound interest and the assessment of it in this case. So let me move then to the first ground. I'll deal with it in three parts. I'll very briefly outline some of the context in which this issue arises. I'm not going to take the court through all of the details of the background, but I'll provide some context. Then I'll look at the law on how to approach quantum, including the case law on uncertainty and issues concerning the broad axe that have been looked at, including drawing on some quite old case law. And then I'll work through the relevant parts of the judgment, dealing with the issues about the approach to a proof of damage, and explain why the tribunal's approach doesn't concur with the proper legal approach and why it matters in this case. So I'll deal with it that way, if that's acceptable to the court. So just some context. You'll have seen that the context can be relatively simply described. The appellant was, with other truck manufacturers, the subject of an European Commission settlement decision, which made a finding of infringement that the appellant, with others, had been party to an agreement to share information about gross list prices. Now, gross list prices are not the same as actual transaction prices, but list prices for the trucks, the vehicles in question. And I refer to it as a settlement decision. That is to say that the appellant accepted it didn't challenge that it had breached Article 101 of the European Treaty, which prohibits agreements that may prevent, restrict or distort competition. Now, in the light of that infringement finding, a substantial penalty was paid by the appellant. But in addition,
700 and something million euros.
a substantial amount, yes.
Extremely. It was one of the biggest fines ever imposed, I think.
Yes, the fines in total were large.
2.9 billion.
Yes,
Yeah.
but as the the court may anticipate, one of the reasons for settlement is that the level of penalty may be lower if you settle and you don't contest with the Commission.
Would have been even higher if you'd fought it.
That is the expectation in these circumstances. And it is, of course, worth bearing in mind that the finding of infringement is a finding that the object of the arrangements was to prevent, restrict or distort prices. In Article 101, infringement can either be by object or by effect, and this was an object case.
My recollection is that object doesn't really mean purpose, it means it's obvious.
It's certainly not the purpose that is critical, it is the type of infringement that matters. And you are right that cases are put, as it said, in the object box when they are the type of conduct that gives rise to particular competition concerns, yes.
Had this in FX in spades. What was meant by object and the extent to which it could or did encompass some element of effect.
Yes.
So anyway, they were, as ever, in settlement agreements, the Commission, in settlement decisions, the Commission goes for object. Doesn't have to go for effect. It's easier to go for object, so it does.
Well, I think that's not limited to settlement decisions, of course.
Sorry.
That's not limited to settlement decisions, of course. And indeed, in this case, there was one party that didn't settle, Scania, and that it then had a decision against it. But of course, that was an object infringement as well. So I think this has been a long-running discussion. Regulators tend to pick object cases because proving effect is rather hard. But in addition to the infringement finding, various claims were brought against not only the appellant but against numerous other truck manufacturers, both in the UK and elsewhere, claiming damages allegedly suffered by reason of the infringement. And as the court will be aware of, there were preliminary disputes in the UK about what elements of the decision were binding in UK proceedings, and then there was a long-running discussion in the tribunal before various compositions of the tribunal about the case management of not only this case but numerous others. In the end, the decision was taken by the tribunal that the claim by Royal Mail and BT against DAF alone would be the first case that was heard by the tribunal. But as I say, there are many others involving other claimants and defendants, and that many of those are still pending before the tribunal. They include, as I'm sure the court is aware, class actions in relation to damages claims being brought. Now, the court will also be aware that a number of matters have come before this court in relation to certain issues arising, and indeed some matters have gone all the way up to the Supreme Court. But I don't think any of those issues in relation to the trucks proceedings are germane to today's case. What I want to emphasise, as I had done at the outset, is in taking ground one, we do not seek to impose a spurious degree of precision, in the words of the House of Lords in South Yorkshire Transport, in relation to the specification of quantum. Our point is that the fact that you do not impose a spurious degree of precision does not mean you avoid proving the basic requirements of a substantial level of quantum. You don't have to prove a specific number, you do have to prove a substantial amount. And the other point I think that I'll come back to, But there was a vast amount of evidence provided in this case, thousands and thousands of documents by way of disclosure, including in relation to DAF's pricing. In addition, vast amounts of data was provided. So with that very brief context, if I may, I'll just move on to start with the law in relation to ground one. And in some ways, the easiest way to do it is actually to start with the last authority in the authorities bundle. In the hard copies, it's authorities bundle for tab 36. It's one of the extracts from McGregor on damages, 21st edition. And I will just pick it up. And the page numbering from the authorities hard copy, it's 1785. In the electronic bundle, it's E460, I think.
Volume 4, is it?
Yes, it's volume 4. So you should have an extract, McGregor on damages, 21st edition, procedure, the trial, proof, burden of proof as the headings.
Yeah.
Do you launch it?
Okay, that's paragraph number.
52001. It's a simple and I hope uncontroversial but fundamental proposition. The claimant has the burden of proving both the fact and the amount of damage before they can recover substantial damages. This follows from the general rule that the burden of proving a fact is upon the person who alleges it and not upon the person who denies it. So where a given allegation forms an essential part of a person's case, the proof of such allegation falls on them. Even if the defendant fails to deny the allegations of damage or suffers default, the claimant must still prove their loss. So it's the fact of damage and the amount of damage has to be proved. And obviously in civil proceedings, that is on balance of probabilities. Now, in the context of this case, and more generally in some of the case law I'm going to come on to, one of the questions that arises is, how does a court deal with questions of uncertainty in relation to that question of proof when we're dealing with proof of damages, and in particular the amount of damage? And there are two or three doctrines that have been referred to in the case law and indeed in the respondent's skeleton argument. The first is that which might be referred to as the Armory and Delamere principle, by reference to the very old case that I'll come on to. The second doctrine is that of the broad axe. And the third, which I'll also touch on, is what's referred to as the principle of effectiveness, which is a concept that has been developed in European law and imported into aspects of UK law.
Sorry, what's that third one?
The principle of effectiveness.
Oh, sorry, the principle of effectiveness.
Sorry. So, Armory Delamere, broad axe, effectiveness. Now, in dealing with these principles, it's actually perhaps easiest just to go a few pages back to the beginning of that tab. Again, an extract from McGregor, 21st edition. And this is under the heading Limits of Compensatory Damages, Chapter 10. And it's under the heading Problem of Certainty. And I'll just pick it up, if I may, at 10.001. A claimant claiming damages must prove their case. To justify an award of substantial damages where loss is asserted, the claimant must satisfy the court both as to 1, the fact of damage, that is an adverse consequence, and 2, as to its amount. So that's just echoing what we've seen. If the claimant satisfies the court on neither, the action will fail, or, at the most, the claimant will be awarded nominal damages where a right has been infringed. If the fact of damage is shown but no evidence is given to it as to its amount, so that it's virtually impossible to assess damages, this will generally permit only an award of nominal damages. This situation is illustrated by the old cases of Dixon and Deveridge and Twyman and Knowles. The loss must, however, be an immediate adverse consequence and not merely a risk of some adverse consequence. Now, we have those old cases, but I'm not sure that the court needs to be shown them, even though they are wonderfully brief. They explain how, if you don't make out your proof of substantial loss, you will only be entitled to nominal damages in relation to an infringement of the right.
Sorry, that's not actually what they say. Perhaps you could show the court.
I'm certainly happy to provide them to the court.
What they say is if there is no evidence, no evidence.
Can we make sure all mobile phones are either on silent or off, please?
Sorry, my lord, I interjected just because the cases don't say if the claimant doesn't make out their case. They say if there is no evidence of quantum.
But also I noticed the first sentence of paragraph 10.002.
I was just coming on to that.
There we are.
Yes, that's exactly where I'm going next. On the other hand, where it's clear that some substantial loss has been incurred, the fact that an assessment is difficult because of the nature of the damage is no reason for awarding no damages or merely nominal damages. Then there's a reference to Chaplin and Hicks, the leading case on the issue of certainty. The fact that damages can't be assessed with certainty doesn't relieve the wrongdoer of the necessity of paying damages. Indeed, if absolute certainty were required as the precise amount of loss that the claimant has suffered, no damages would be recovered at all in the great number of cases. This is particularly true since so much of damages claimed are in respect of prospective and therefore necessarily contingent loss. And there's a quote from Biggin and Permanite: where precise evidence is obtainable, the court naturally expects to have it, but where it's not, the court must do the best it can. Generally, therefore, although it remains true to say that difficulty of proof doesn't dispense with the necessity of proof, the standard demanded can seldom be that of certainty. Now again, we take no issue with any of those propositions. And it goes on, even when it's said that the damage must be proved with reasonable certainty, the word reasonable is really the controlling one, and the standard of proof only demands evidence from which the existence of damage can be reasonably inferred and which provides adequate data for calculating its amount. And then there's the quote from Radcliffe and Evans. And if we just go on to 10.003, there's a reference to the case of Zabihi and Janzamini, where the valuation of missing converted jewellery was in issue. And this echoes what had happened in the old Armoury and Delamere case. The essence of the opening 2 paragraphs set out in an earlier edition of this book, as set out by the Court of Appeal, were relied on by Mr. Justice Blackburn below and distilled by him in a statement also set out by the Court of Appeal, that the court must do its best on such evidence as it feels able to accept to place some kind of value on the jewellery, even if its precise identity can't be established and therefore its value must be in doubt. And the Court of Appeal agreed with Mr. Justice Blackburn that it was right to do his best to come with a valuation figure, provided that he was entitled to accept the evidence on which he relied as sufficient evidence of value. And by a majority it was held that he had enough to do that. So we're not saying certainty, we are saying you need to prove substantial loss. And if we go down the page to 10.006, further cases presenting this difficulty of showing the amount of profitable sales that would have been made by the claimant had there been no tort or breach of contract by the defendant have indicated that the claimant is assisted by the principle in the very old case of Armoury and Delamere, which has today received a new lease of life. The principle being that the courts require to resolve uncertainties by making assumptions generous to the claimant where it is the defendant's wrongdoing which has created those uncertainties. That principle was endorsed by the Supreme Court in Morris Garner on one step, but there remains doubt as to the extent of its application. And the doubt concerns whether it's a principle of general application or only to assist in relation to evidential disputes. And as you read on, the authors of McGregor very much emphasise that it should be seen as a means of resolving evidential disputes. And in particular at 10.007, there's a reference to the case of Porton Capital Technology Funds. And I do want to just take you briefly to that case, if I may. So it's Authorities Bundle 1, tab 11.
Are we leaving McGregor?
Yes, I would commend that, the whole of that paragraph, but I'm dealing with it through you, so. Bundle 1, tab, Authorities Bundle 1, tab 11. And I don't think the details of the case need detain us in relation to the matters. It begins in the hard copy at page 259, the case. But where I want to go is at page 296, paragraph 237. This was a shareholder dispute involving breach of contract, but the same sorts of issues arise. And this is Mr. Justice Hamblin, as his name was. The claimant submitted that whereas here the very actions of the defendant in breaching the contract have made the quantification of damages more difficult, the court should resolve any uncertainties in favour of the claimant. It relied on the old decision of Armoury and de la Mairie, in which a boy chimney sweep had found an item of jewellery in a chimney and taken it to a goldsmith to be valued. The goldsmith told the boy that the piece was worth 3 halfpence, which the boy refused, and the goldsmith returned it to the boy, having removed the jewel. The boy sued the goldsmith in trover. Chief Justice Pratt directed that unless the defendant produced the jewel and show it not to be of the finest water, they should presume the strongest against him and make the value of the best jewels the measure of their damages. Then there's a reference to the Browning and Breakers case about values of property, referring to value of property in relation to negligence of a solicitor. That's dealt with at 238 and 239. Then at 240, there's consideration of the Ferns Anglo-Dutch paint case and observations by George Leggett QC, as he then was, dealing with these matters and citing General Tyre and Rubber, Lord Wilberforce. Then there's reference most recently, as Mr. Justice Hamlin put it, to Double G Communications. And it works through to 243, to the Zabihi and Janzamini case, which is referred to by McGregor. And I commend these paragraphs to you, analysing the operation of the Armoury and de la Mairie principle, because it supports the conclusion of the authors of McGregor. At 244, this is not a case concerning the value of goods which the defendant has refused to produce, or of the suppression of evidence, as in Armoury and de la Mairie, nor is it a case involving the loss of a chance of success in legal proceedings, as in Browning and Breakers. It's a claim for loss of profits, for breach of contract. There is factual and expert evidence before the court relating to the claim. There is documentation before the court relevant to the claim. The evidential playing field is a level one. Whilst it's correct that the claim involves a degree of conjecture, that is the case in relation to very many contractual damages claims, and I would interpolate tort claims as well. And in all such cases, it can be said that it is the defendant's breach of contract which has made the conjecture necessary. As a matter of authority, there is no requirement to apply the principle of Armoury and de la Mairie to a case such as the present. And as a matter of principle, I consider there is good reason not to do so, and the application of the principle should not be extended further than is necessary. And of course, that is understandable, because if you extend the principle of Armoury and de la Mairie beyond these particular instances of a deprivation of the essential evidence as occurred in the Armory and Delamere case, or possibly in relation to loss of a chance, you effectively undermine the burden of proof that is being properly imposed on a claimant in relation to the amount of damages. So yes, there is a tool there, but no, it should not be applied too extensively. Now I should refer to the One Step and Morris Garner case, which was also referred to by McGregor, which is in Authorities Bundle 3 at tab 20.
Just before you move on.
I'm so sorry.
No, not at all. In paragraph 244, where the judge is referring to a case such as the present and trying to limit the scope of the duty to a breach of contract case, is he saying anything about how it might apply in a case involving the public interest?
In a case involving the public interest? Well, there are cases involved. In some ways, the enforcement of contracts and the enforcement of tort law can all be seen as matters in the public interest. If you're talking about tort in relation to a damages claim in relation to a tort, it's not clear why particularly there would be a specific public interest issue arising, particularly in the context of situations where, of course, you have public authorities actually imposing penalties in relation to these matters. But more generally, nothing in any of this case law suggests that in damages claims, such as this, you should somehow attenuate the burden of proof in some more general way by applying a principle that effectively limits that burden of proof. Yes, you are talking about not a specific number, but no, you still require the burden of proof. And Armory and Delamere should not be extended further. And there isn't a justification for talking about, for instance, competition cases as having a particular public interest. There's no reason why a competition case should be seen as more in the public interest in this regard than, for instance, a breach of quality of sales case, for example, where people suffer harm in relation to negligent provision of products or negligent provision of services. And therefore, I would take issue both with the implicit suggestion that there's any public interest here, but also the basis on which...
The judge is saying, I mean, he just says, to a case such as the present.
Yes.
And he wouldn't extend it further than is necessary. I mean, a very long-term, tortious, concealed cartel case isn't necessarily the same as an ordinary breach of contract case.
Well, in some ways, I'm reminded about Jackson Elephants and posting letters. You're obviously right. There is a difference between a breach of contract case and an infringement case. On the other hand, for instance, tortious cases can be extremely long-running. Other sorts of contractual breaches can in fact be long-running. It is right that in relation to questions of proof of liability, it has been observed that there can be an asymmetry of information in relation to the actual proof of secretive arrangements. And yes, those principles have been applied in relation to liability, notwithstanding that actually the object test makes the proof in some ways easier of an infringement. It is difficult to see how those sorts of principles carry across into the next stage, where you're talking about whether or not someone should recover damages in relation to these matters, where what you're talking about is a situation where you're asking yourself on a counterfactual basis, what would have happened absent a tort? Torts, as I say, can be extremely long-running. It means that the Leoma cases were incredibly long-running tortious infringements, for example. In those circumstances, there is no basis on which it should be said that in fact you should attenuate the basic balance of probabilities or burden of proof condition beyond that for saying you don't have to prove on the balance of probabilities some specific number.
So this is a case in which, in very broad terms, that the claimant's case is that there was an overcharge as a consequence of this secret cartel. 14 years. And the claimants say that the defendants have failed to disclose any of their own documentation about how they conducted the cartel and why it existed and so on and so forth, as a consequence of which there is an evidential gap caused by the defendants, and that's the context in which the tribunal had to decide this question.
Well, let's take that in two stages. First of all, it is not correct that the defendants didn't provide disclosure. They provided disclosure of all of the
Well,
relevant.
they provided disclosure of the commission documents. They didn't provide any evidence or explanation as to what they were doing.
They
And
didn't.
what the consequence of what they were doing was, or what they thought the consequence was.
They didn't provide witness evidence in relation to those matters. That is absolutely right, and that was explained at the time of the trial. They did provide any documentary material that they had in relation to all of those issues. So that would not be a fair criticism. They did so both to the Commission and as part of the disclosure exercise in relation to this.
Yeah.
Second of all, in relation to this consideration of whether or not harm has been suffered by somebody, in relation to what is effectively a form of economic tort here, it's a breach of statutory duty, but we're effectively talking about an economic tort, we actually have a public enforcement regime that is there to protect the public interest separately. That is why the defendant ends up paying the very significant penalty. So this would be absolutely the wrong case or type of case to be suggesting that one should somehow skew the burden of proof in relation to these matters because you're dealing with a competition claim. And as is rightly observed by Mr. Justice Hamblin here, in all cases, or almost all cases, involving breaches of contract and torts, where you don't have, for instance, a liquidated damages provision, or you're not just identifying the cost of repairing a car, you are going to have an uncertainty as to the nature of the counterfactual. And as Mr. Justice Hamblin observes, in all of those cases, the need for conjecture arises because of the breach of contract or the tort. And in those circumstances, you need to be extraordinarily cautious about saying that competition cases are special in relation to these issues, and somehow the burden of proof or the approach to evidence should be attenuated in relation to any of these matters. Those involved in competition cases obviously love to think of themselves as dealing with something special and important. But overall, when we're talking about the public interest, it is difficult to justify that position a fortiori when you have a public enforcement system there, which is there to protect the public good.
Ping pong, yes and no. Yes, I agree with everything you said, subject to the fact that, of course, the Court of Justice said that private enforcement serves an important public end. And that may be a statement of the obviously could apply, I suppose, to contract. But you're right, there is a public enforcement mechanism which is designed to punish and deter. But so is damages.
Well, that's
that
true in relation to, if we go back to product liability, then obviously a private, you do have systems whereby there are regulators that can take action in relation to product liability, but the damages claims that can be brought in relation to public liability fulfill a significant practical deterrent effect. I'm not disputing any of that. I'm not disputing any of that reasoning on the part of the Commission, but that does not mean that you change the evidential standards that you're dealing with here.
Is it really a matter of changing the evidential standard? I don't suppose anyone's saying the burden of proof shifts, or it's not the balance of probabilities. I mean, maybe when one gets to extreme, it is the balance of probabilities, or is it really just the judicial approach to evidence within those confines?
Well, that's why I was cautious to use evidential standards rather than necessarily the standard of proof itself. The truth is that the more that you say, well, you created the uncertainty and therefore assumptions will be made against you, in practice what you are doing is lowering the standard of proof that has to be met in relation to a claim by a claimant. Because essentially they are able to rely on presumptions of non-provision of evidence rather than actually discharging the burden of proof. Now,
I wonder if that's always true. If it was let's assume for the sake of argument that going back in history you weren't able to provide as much disclosure as you could for more recent events, but it was plain beyond peradventure that that earlier lack of evidence had no bearing whatsoever upon any issue as to quantum. I don't think the judge or court would say we're going to hold that against you and lower the standard of proof. It rather depends upon what it is that you haven't disclosed and its potential impact, and whether an inference can be drawn that should be held against you. And is it really any more than just the evaluation of evidence?
well, it is more than the evaluation of evidence, because essentially what you're doing is you're counting on the absence of evidence.
maybe the absence of relevant evidence, or the
Well,
absence of possible
sorry, I
relevant
predicate,
evidence.
your lordship is absolutely right, it has to be relevant evidence, but I was presuming we're dealing with relevant evidence.
Okay.
So I think we can, we're dealing only with
Well,
evidence.
the absence of relevant evidence is a consequence of or because the defendant has chosen not to call it or not to
Well,
induce it. That's the point, isn't it?
Well, no, with respect, I think in circumstances where, if we went back to an ordinary liability case in tort, if a claimant brings a tort claim and a defendant doesn't produce witnesses in relation to particular issues, then in those circumstances, yes, in extremis, there may be inferences drawn against them in very restrictive circumstances. But the basic proposition is that in relation to liability, you have to prove your case on the evidence. The same is true in relation to quantum, and that is essentially what is being lost in a lot of this discussion in the case law. That instead of focusing primarily on you need to prove substantial loss, albeit not to a point of a specific number, you do need still to prove that. Now, if your lordships say, well, that is a matter of the treatment of evidence, then in broad terms, I can't possibly disagree with that proposition. That's obviously right.
I mean, in one sense, this is a slightly funny sort of claim in the sense that the extent to which the defendants might be thought to have suffered loss could be thought to depend to an extent on what you did with the information.
Yes.
Do you accept that it was legitimate for the CAT to have regard in its assessment of these matters to the fact that you had not called witnesses to explain what you did with the information?
Well, we say that in relation to the failure to call witnesses, that actually that was not germane. But that is primarily because the proof that is relied upon by the claimants and indeed by the tribunal to identify the quantum was agreed to be by way of economic evidence. And it is that that founds the proof here. Because it is only by carrying out, and this was agreed by both sides, it is only by carrying out those sorts of analyses of data, all of which was provided, because all of the pricing data that we're talking about was provided, it was available, that the tribunal made its findings as to quantum of loss. And so I don't need to clash with the tribunal about how it dealt with the absence of particular factual witnesses, because the basis of its findings on quantum concerned the economic evidence. And what I'm going to come on to do, once I've finished on the law, is explain by reference to the judgment why in particular the findings that were made by the tribunal itself about the strength of the claimant's economic evidence showed that it did not cross the relevant balance of probabilities threshold of showing substantive loss. And I'm going to focus on two aspects that are critical. One is the extent to which the so-called cartel effect, which was being identified, was actually just a product of exchange rate fluctuations between the pound and the euro. And the other was because of the way in which the claimant's expert dealt with the global financial crisis. So the key point here is the driver for proof is the economic analysis, and it does not cross that threshold.
Is this the reverse? What's your position? And maybe you'll come to it later. I think it was in Sainsbury's on the passing on defence. So it's a defence, and if the claimant doesn't provide disclosure, the court said that inferences could be drawn against the claimant in favour of the defendant. Is this any more than that? Reverse. That would be in your favour. This is against you. Is it? Do you agree with that? I mean, is that a position you take in relation to the passing on defence, that if adequate disclosure isn't provided, a court can make an inference in your favour against Mr. Ward's client?
Let me be clear. Where a court lacks particular evidence, we're not saying that the court just makes no attempt to assess the position at all. And if disclosure was specifically not given for a particular reason, that might be material. But that's not what we're dealing with here. And so I don't have to disagree with the way that matters are approached in relation to the pass-on analysis in the Supreme Court in order to be able to hear.
But you agree with it.
I
The
don't
point is
have
it's
to.
in your favour.
Well,
I just wonder if it's exactly the same principle in reverse.
Well, what the Supreme Court is talking about in relation to issues of disclosure there is that if once you've passed the legal causation threshold, which we will be coming back to, what the Supreme Court emphasises is that because matters concerned with passing on by a claimant are going to be predominantly within the scope of the knowledge of the claimant, that in those circumstances, the burden of providing the relevant disclosure will fall on the claimant, and if it doesn't do so, there may be issues arise. Here, the burden of disclosure in relation to the overcharge, obviously for the reasons that my Lord Justice Newey is adverting to, fell upon the defendant. We had to provide vast amounts of the data that showed how we actually engaged in the pricing. Now, if we'd not done that at all, and therefore you didn't have the evidence, we could see that you'd be in a different position, and there would be a parallel with the position in relation to passing on. But that's not the situation you have in relation to this overcharge claim. I'm very briefly going to deal with One Step and Morris Garner because it only has a couple of paragraphs in, just to tidy up of the references from McGregor. So it's in Authorities Bundle 3 at tab 20, if I may.
37 and 38, isn't it?
Yes, that's it. You're well ahead of me, my lord. That's all I really need to go to here.
Shall we just read those to
Yes,
ourselves?
do feel free. So the first paragraph dealing with broad acts, the second on the armoury and delivery principle, we say it takes matters no further forward. So the two principles that I am dealing with, albeit in reverse order, broad acts and then armoury and delivery. The one thing I would note in 37 is the emphasis that the quote with approval from Parabola Investments, Lord Justice Toulson, about the balance of probability test being applied to the measurements of loss. Right at the end.
No, not apply.
Yeah, it doesn't apply.
But when it doesn't apply, this
Yeah.
is saying where,
Exactly.
as a consequence of the defendant's wrongdoing, what you're trying to work out is what would have happened in the counterfactual situation had it not been for the wrongdoing.
Yes.
Then you don't apply a balance of probability test.
Yeah.
The law doesn't require the claimant to perform the impossible.
Precisely.
I know a bit about this case because I was the judge at first instance.
Yeah.
Um,
Yes, absolutely.
Unless you're going to say that that statement is wrong, as
No,
approved by the Supreme Court, it seems to me to be of some relevance here.
Yeah, I'm certainly not going to do that. But what I'm doing is explaining how that works here in the context of the use of the broad acts and the limitations of the armoury and delivery principle.
Yeah. Okay.
Because, as I say, in armoury and delivery, as described in the Portland case, we're dealing there with a valuation of property where the property has effectively been removed. So what we say in relation to the armoury and delivery principle is that insofar as it's now being relied on by the respondent, we say that that doesn't take matters further forward. It's an evidential condition as referred to by the authors of McGregor, and it is of limited scope, and if it is unduly extended, it undermines the balance of probabilities test being applied. But that then takes me to the second of the principles, which is the broad acts principle, which was being referred to in paragraph 37, one step. If I may, I'll just go back very briefly to the start of where this is dealt with, which is in Watson and Laidlaw. So it's Authorities Bundle 1, tab 4, page 41. So I think this is the first identified use of the notion of the broad axe. So I'm sure the court's familiar with this case. It's one where it's a patent infringement action where at first instance an award of £1,500 had been made. The Court of Session awarded £3,000. The appeal was it justified to sustain this £3,000 damages measure. The dissenting judgment was given by the Earl of Halsbury, who suggested that there was no good basis for the Court of Session to overturn the first instance finding of £1,500. And it's just worth noting, I don't think this is actually anything disputed by the remainder of the judges, but on the first page, I regret to say I'm unable to concur, and then the emphasis on the burden of proof lying upon them, and apart from evidence which of course may shift it, that burden lies upon them to the end, no matter in what stage of litigation the question arises, and that's in relation to the amount of damages. Right. But then if we go on to the judgment of Lord Shaw, which is the part that is regularly quoted and is seen as the origin of the concept of the Broad Act, you can pick that up at page 52. In the case of damages in general, there's one principle that does underlie the assessment. It's what may be called that of restoration. The idea is to restore the person who's sustained injury and loss to the condition in which he would have been had he not sustained it. In the case of financial loss, injury to trade and the like, caused either by breach of contract or by tort, the loss is capable of correct appreciation in stated figures. In a second class of cases, restoration being in point of fact difficult, as in the case of loss of reputation, or impossible, as in the case of loss of life, faculty or limb, the task of restoration under the name of compensation calls into play inference, conjecture and the like, and this is necessarily accompanied by those deficiencies which attach the conversion into money of certain elements which are very real, which go to make up happiness and the usefulness of life, which were never so converted or measured. The restoration by way of compensation is therefore accomplished to a large extent by the exercise of a sound imagination and the practice of the broad axe. So that's the first reference to it. And I think there are a couple of observations obviously to be made about that. The first is that the language of the broad axe is being deployed in relation to loss of reputation or personal injury matters where assessments of general damages might be difficult, but that is actually in contrast to the language used above in cases of financial loss, injury to trade and the like. And so what is being said, of course, is...
That was the quote, the loss is capable.
Yes, capable of...
100 years on, and with the proliferation of regression analysis and econometric modelling, life ain't so simple.
And also, as one step makes clear, there are financial loss cases where quantification is extremely difficult, not least because you're looking at a counterfactual.
Yes, all of this I entirely concur with, and I'll be coming on to deal with the cases where obviously the use of the broad axe has been extended beyond the general damages cases. The point I am making is that its origin is in this context. It was limited. What we are dealing with essentially in ground one is allowing the broad axe to have been used far too liberally in this case.
A moment, because he goes on to say the same principle applies in patent cases.
Yes, and I was just going to
principle of
come on to do that.
restoration. So he's actually saying in a species of financial loss,
Yes.
of which financial...
I'm sorry, I was coming on to deal with this. Because actually what this case is to do with is whether or not you could take into account royalty rates as to the quantum of loss. And so this case is not only the origin of the Broad Acts, but it is actually the origin of why in patent cases you are allowed to claim losses by reference to royalty rates, rates of hire, what then got discussed in terms of Rotham House damages, Rotham Park damages.
Ruton Park.
Ruton Park, I'm so sorry.
We say things differently in the QBD as well.
Yes.
That's
KBD.
chancery speak.
I was having terrible flashbacks to restitution ceremony. So often. There would be. This is a case where it's absolutely right that what it did was it referred to the notion of the Broad Acts in terms of general damages. That was the starting point. It was limited in play. It then goes on and says, actually, in the context of patent cases, particularly where a patent could be infringed, and it will be very difficult to say that you actually lost out. And in this case, this was to do with sales of sugar processing machines in Java, and the court said, well, you wouldn't have been able to sell those machines in Java unless the infringing agents had done the selling. And so there wasn't a direct loss for the claimants, but it's then said, but something happened here by reason of infringement. You should get something back, and we will award a royalty rate. And at that point, of course, there is an assessment of what the royalty rate is. And of course, in relation to the royalty rate, it is not an absolute and precise figure that can be seen because it's hypothetical in those circumstances. But an assessment can be made by reference to the evidence. So this is precisely the sort of case where, because of the actions of the infringers, you don't actually know what would otherwise have occurred, but the court can use the Broad Acts going beyond general damages in order to afford proper justice for the claimants whose patent has been infringed. And it's on that basis that the court says, well, you would have had these royalties. If you'd have had these royalties, they would have bumped up the infringement damages at least to £3,000. We'll stick with the number that the Court of Session had. So I am not suggesting for a moment that is limited to general damages, personal injury. This court illustrates why it's not. But what this process also shows is how it started and why it is of more limited compass. That's what we draw from it, not that it is specifically limited to reputation or outside financial loss cases. The next case I'm going to go to is the Britned case, which is on Authorities Bundle 3 at tab 21. Now, Britned was a competition damages claim brought in relation to power cables infringement involving various power cable manufacturers, including ABB. It starts at page 1083 in the hard copy bundle, but I'm going to pick it up, if I may, at page 1095, paragraph 10. Under the heading Legal Principles and Approach. And it is just worth bearing in mind in this case, there were claims in relation to overcharge, but there were also claims in relation to loss of chance to win or obtain certain cables. And the reason that matters is because some of the references to the case law are about loss of a chance. So initially there's a discussion in paragraph 10 of the elements of the tort, and then paragraph 11, it's often said that in terms of what a claimant has to prove in order to recover loss depends on the distinction between past facts and future events or hypothetical actions. And obviously in relation to the quantification of damages that we're talking about, you are in fact talking about past facts, but we also recognise you're talking about a counterfactual. We understand that. And then in paragraph 12, you'll see what the tribunal thought was a helpful summary of the law. First of all, in 1 and 2, about the ingredients of statutory duty. That's also true in 3 and citation of McGregor, albeit focusing on loss of a chance at that point. 4 is also really about liability. Then we move to 5, which is talking about the nature of loss and damage. And it's noting in 5 at the bottom that the inquiries, if we pick it up halfway through, the measure of loss in tort cases, the amount of damages that will place the claimant in the situation he or she would have been in had the tort not been committed. Both of these inquiries involve an assessment of what would have happened in a hypothetical or counterfactual case, a case where the contract was performed or where the tort was not committed, so the claimant's damages can be quantified. And then 6, during this quantification, English law moves away from the balance of probabilities. Now, this is the phrase that's been emphasised repeatedly, and I think this is one that we need to be cautious about. It is true in one sense that English law does move away from a strict approach to the balance of probabilities, and indeed that was one of the points that was being raised in the Parabola Investments case as cited in one step. But it's doing so because it recognises that you can't, in relation to quantum of damage, be trying to prove as more likely than not some particular figure. That might work in relation to, for example, the cost of repairing damage to a car, but generally it will not. And therefore you are in territory where you are looking at a broader range of potential figures. We entirely accept that, and it is for that reason we say our argument is not for a spurious degree of precision.
But what the judge is saying here is where you're dealing with an assessment of what would have happened in a counterfactual situation, then English law moves away from the balance of probabilities. Why isn't that principle applicable here?
Well, we say that insofar as it's saying you move away from the balance of probabilities in the sense that you need to prove as more likely than not a precise figure of quantum, that's obviously right. If what it's doing is saying, no, so long as you've shown there might be some loss, then you fulfill a role rather more like an investigating magistrate, then we say that is not correct and that has gone too far. You still need to prove substantial loss. You need as a claimant to put forward evidence that shows there was substantial loss. And that is important here, because if you don't do that, you're essentially negating the basic proposition that was being put forward in McGregor that someone has to prove the amount of their damages. And what is the test if you're not asking someone to prove on the balance of probabilities that they have suffered substantial loss? Yes, the court can bring to bear a degree of assessment, but no, it is not enough to simply ignore those principles of evidence. And the Broad Acts can help you in the refinement of that assessment, but it is not a substitute for proof. And that is the essence of our point on ground 1.
Mm.
And we say that nothing in this case here, in paragraph 6, where it is notable, of course, that the bits of McGregor that are being cited are actually in relation to loss of a chance cases, where obviously we're dealing with something very different when you're dealing with loss of a chance. That one needs to be extremely cautious that one doesn't read this case as suggesting somehow that there has been some significant attenuation of the basic principle that you have to prove the substance of your loss. Then at paragraph 7, so there's then citation of a case, another competition case, Asda and MasterCard, and this is one of a huge number of cases about the multilateral interchange fee, yet another grand series of competition damages cases. And 7 refers to what Asda says is what is helpfully set out as the approach the courts take to questions of quantification. And I'd ask you just briefly to read through that 7 and 8. Actually, right the way through to the end of 9 is probably easiest.
Well, what he says between B and C on subparagraph page 733 of the report is actually the package which is upheld by the Supreme Court, isn't it, in the sense that they disapproved of what Mr. Justice Popplewell had said
Yes,
about undercompensation.
yes, that's right. Yeah, that's absolutely right. But so, not an unreasonable insistence on precision, entirely accepted. There was criticism of this as perhaps accepting a presumption of undercompensation. That was, the Court of Appeal then said that wasn't what the judge was doing here. But it must be grounded in the evidence. And we say that there is nothing here that should be seen as attenuating that basic proposition that you must discharge the burden of proof in relation to substantial loss. And I'll just complete that by going on to the Court of Appeal, which is in the next tab, tab 22. And I'll just pick up one or two paragraphs briefly in this, because this picks up precisely the point, my lord, that you were highlighting. If we pick it up at page 1281,
1281.
yes, so just the heading above paragraph 51. So this was the question. You'll see the heading is precisely dealing with the question that you were, my lord, considering. Did he err on the side of undercompensation? And issues were made about the role of European law, albeit that at paragraph 54 it's made very clear from guidance from European institutions that standards of proof, burdens of proof, and evidence are matters of national law, which comes as no surprise. If we go over to paragraph 57, I'll just pick this up as along the way, because this goes to the third of the principles. This is the principle of effectiveness. So the principle of effectiveness is about making something impossible or excessively difficult. The European cases tended to be about things like very strict limitation periods. But it's being said that even if there were some issue, then the broad acts, the ability to attenuate the way in which you consider evidence can deal with those issues. So there's no issue, is the short point on effectiveness. And if we go on to 65, this is the point at which the Court of Appeal says it wouldn't espouse any presumption of erring on the side of undercompensation, which we entirely accept. And then it refers at the bottom of the page at H, the broad axe or broad brush. And what we would say is that the parentheses here actually reveal to some extent the problem that we've encountered in this case. The vivid nature of this metaphor of the broad axe has come to effectively overtake the basic legal doctrine. And indeed, if one turns back to paragraph 60, although the Court of Appeal didn't approve any erring on the side of undercompensation, it did approve Mr. Justice Popplewell's statements about what broad brush or possibly broad axe meant. And then just finally on this case, at 1329, 244, paragraph 244,
Sorry,
page 1329 in the hard
right
copy.
way on.
Same case, paragraph 244.
Yeah.
And just pick up the last sentence. The re-emphasis that the burden of proof lies on the claimant to establish he suffered loss and the quantum of that loss, albeit he may benefit from the application of the broad axe principle. No issue. We are not disputing the existence of the broad axe. We're disputing how it has been used here. And I hope by going through some of that case law, one can see how it has developed, but how those concerns are being expressed at that point by the Court of Appeal about the undue use of an unduly vivid metaphor. And two further cases that I'm going to briefly deal with are Sainsbury's in the Supreme Court and the Gutman case, which obviously...
We'll do those after a break.
Yeah, absolutely.
So we'll take a break for 5 minutes. Please, somebody ensure that my Office 2 and Lord Justice Claimants are working when we come back. It's extremely irritating and difficult not to have it. Particularly, I mean, obviously we're following what you're saying, but on the basis that there's going to be a transcript. But it's just much easier to follow when there's citation of authority. If you've got a screen running where you can actually read what's being said.
Completely understood, and that's obviously why the party
So
wanted this.
that can be solved, please. We'll come back at 10 on that clock, just 10 to.
Go on, guys.
That one.
They were locked into the wrong company.
What about the clerk or this other job? Is he been using it? Is this been really? We can put him in the set, so he's not going to market it. Yeah, we can just put them on a kind of emergency account.
Is he misagreeing? No.
And have all of the judges had a problem things if you're about to come to the unclear whether he's definitely had a problem.
He was just on the wrong one.
He just had it up.
Yeah.
Yeah.
On the right.
Any other? Yeah.
They weren't quite clear. Can we put the other one out?
Yeah.
Say.
No, each account will be locked.
Yeah.
Because we've got this bill that we could.
But then if the judge is making any notes, you
Yeah.
won't see them.
Well, obviously there is a big public interest, they see it as a public interest. And actually, one of the issues do this point, competition principle is out the window.
Yeah, I mean, this one he was on all the time, he just hadn't clicked DAF Trucks, but it was working all the time. So that's working. This one, Opus, has got a spare account, generic account that can go on. Unclear whether this judge has been having Opus for the first session. He didn't really say. Doesn't look like it. We can just bring up one of our
I really think we should.
because this is just shut. I didn't even think he's been attempting. sure it's on. Yeah, it's on. I can, Michaela, can we sign out of the one back there, Vivian, then I can
I'm just
sign
gonna
in on
reset
Michaela's
Green's
account.
as, so yeah, we're gonna reset these ones.
Could you just lock him on a generic account over there rather than
So
reset
we're gonna
the-
get these ones reset and I'll write them down and post it
Oh,
now,
you'll write
and
them
then probably
down.
send them via email as well.
Okay, but you'll be able to log him in now, right now.
So
kind of
yeah,
thing.
yeah,
Yeah.
as soon as I have the details, we can
Okay.
do that.
Annabelle, can you just use this one? It's working on here, I just need Michaela to bring.
Are we sure he wasn't using it?
He wasn't using it.
Was he on his personal laptop?
Maybe now this is in the way and he wants to, I think he's just using hard copies and writing notes.
Shall we log on?
But we should log them all on, I think, because they were complaining.
So, yeah. Make sure they've all got the real time.
Yeah, this is, they need to spell one. Can we log yours? Yeah.
Not sure how useful is the Supreme Court. How useful is the Supreme Court? It doesn't.
Is this like just do a reset?
Yeah, so I'm waiting for Emma to reset his details and is it a, and then I can,
Just the piece because we want to. It's on the statement of account.
Is that coming back in a couple of minutes? Is there, do you have another generic account? You said you
No,
could use for this.
I can use the one for the editor.
I mean, how much does it?
Karen has, but if we're using it on their.
No, we're not, we're using that on one of ours, one of the appellants accounts.
So we can
So
use these.
can we just do editor, because we need it on in time
Oh,
when
no,
they come
she
back
sent
in. But she sent it, okay, you've got it.
Yeah, I mean, you asking about overcharge.
Yeah.
I didn't particularly advance on the overcharge.
In the interest of time.
Yeah, is that okay? Let's go back down.
So-
Go down to the end.
I've received Charmaine Hunty for this one,
Yeah,
is it
yeah,
correct?
yeah.
As the email, is it the
Yes,
clerk?
that's the right clerk, yeah. See if
So
that
it was
works.
being logged on with the wrong.
Yeah, it's in his clerk's email address.
Do you understand?
Yeah.
Yeah, so they have two workspaces again, so they need to select before they start. They should log out.
That's
Can you just connect me?
Yes.
Yeah.
This one was already logged in. It was just the wrong one.
Yeah.
It was just on the CPO's
Because these judges are on multiple cases, they just needed to select this.
the right case.
But they were logged in fine.
Okay.
It's worth having a
Yeah.
They just should log out on the lunch break and then should pay. And we make it against the mail right. So this one, no, that is when they're looking for it.
Yeah.
only have one.
Yeah,
Right.
you're in that. Maybe we just do the competition no scope for the application to go first. When it goes to the point.
That's rejected.
It's rejected. I'm not saying it's
Corais.
Right.
During the break, there were various people having looked at the various
Discovered that
machines.
we were logged into the wrong case, I gather. So
Apparently
this is
this
a new
is-
variation on
Yes.
getting it hopelessly wrong. Anyway, I think Roger's Green, well, I'm sure Roger's Green had not thought that would apply at all, but I've calmed down now. But what I will say is that my intention, we having discussed it outside, is that I will speak to the Master of Rolls about possibly issuing a practice direction, which informs transcription companies that this system, or whatever system we're using, must, as I said earlier, be demonstrated to be up and running, working properly, before the court comes into court in the morning, and the court simply won't come into court until it's assured that it is. I know it isn't your fault, and it isn't your instructing officer or anybody else's fault, but this, as I said earlier, this is about the fourth time this term that with Opus 2 I've had a problem of one type or another.
Can all understand the
It's
frustration. Yeah.
And it's disruptive.
Yeah.
Anyway, thank you. You were going to share Sainsbury's in
I'm briefly going to show you Sainsbury's, although I'm going to be coming back. So it's
the Supreme Court?
yeah,
or in the-
Supreme Court, so volume 4, tab 23. The reason I'm doing this is because there's a big section on the broad acts, but it's mainly to do with the pass-on issue.
Yeah, I
and so I'm
know,
going to be
I know.
coming back to it in more detail in.
It's that bit around paragraph 216.
Yeah, exactly. But can I just, sorry, you're
It was printed on my memory, Mr. Burt.
yes, I'm sorry.
I can't remember which one of us wrote that part of the judgment.
it's-
It might have been me. actually,
This is
according to
possibly
the
a
judgment.
situation of competition law being in the public best interest. But yes,
Yeah, okay, so which bundle is it in?
yeah, well, so the broad acts discussion actually starts at paragraph 175,
And that's where.
page 1379 in mine, 855 internal numbering.
Hang on a second, I'm not sure.
Volume 4, I'm so sorry, it's volume 4, tab 23, I apologise.
Yeah, okay, got it. Page.
1379.
Okay.
So there was a lengthy discussion of the broad acts issue here, and I will come back to it. But I'm just going to pick up a couple of very brief points. First of all, there is nothing in here suggesting that the basic approach to where the burden lies is in relation to the primary overcharge claim is in any way attenuated by any of this. But it is just worth picking up paragraph 176, where MasterCard is raising an issue about the degree of precision that's being required, and referring to the judgment of the Court of Appeal, and talking about the Broad Acts principle.
Yeah.
And you'll see the quote from the Court of Appeal that's taken issue with here, where it said the Broad Acts principle is applicable where the claimant has suffered loss as a result of the defendant's culpable conduct, but there's a lack of evidence. There's no scope for the application of any such principle where the burden lies on the defendant to establish a pass-on of unlawful overcharge in order to reduce the amount recoverable by the claimant. And there's then some fairly extensive discussion of various issues, including the position in the US, where obviously things are rather different because there are legal restrictions on whether or not you can actually bring indirect claims and so on. But if we just move through, for these purposes, to page 1386, you've got mitigation and the burden of proof. And you'll see at 207, Visa and MasterCard submit burdens on the claimant to prove its loss, taking into account any pass-on. So this was the argument you'll be familiar with, which was being said by Visa and MasterCard. You owe claimants have to actually prove your loss less pass-on. All of the burden lies on you. And the Supreme Court rejects that, and rejects it for the reasons that are then articulated at 208 onwards. But the point I think is worth, which is potentially useful in this context, is if one goes over to 1388 from 217 onwards, where it talks about the degree of precision required in establishing the extent of pass-on of an overcharge. In 217, the court in applying the compensatory principle was charged with avoiding undercompensation and also overcompensation. And I just in parentheses say, well, when Lord Justice Green was raising these issues about the public interest, I mean, what is clearly being said here by the Supreme Court is neither higher nor lower. And there is no, it's very different from the situation, say, in the US, where you've got treble damages.
Absolutely.
So, but the reason that I highlight this and 218, which refers to Livingston and Royards and Watson and Laidlaw, is when we get down to 219, what is emphasised is that there remains room for the Broad Acts principle in assessing compensatory damages on either side. In other words, the Broad Acts principle isn't driven by some sort of culpability issue here, which was what was being argued about previously. Now, I will be coming back to this case in relation to the pass-on, and I'll...
This is just dealing with pass-on, isn't it?
Absolutely. So
I mean, earlier on, they reiterate that once you establish that there is a loss, in a counterfactual situation, you can use the Broad Acts to establish the quantum of the loss.
yes.
This is dealing with the obverse point about whether you use the Broad Acts for the purposes of
Yes,
establishing the amount of pass-on.
Exactly, and the point I was just emphasising by reference to the quote I took you to from the Court of Appeal was that it was being argued that there was no scope for the Broad Acts on the pass-on side because there was obviously no culpability issue. And what the court is saying, no, this is just a more general principle we apply. But the point I make is that although it's a Broad Acts principle that applies equally whether you're proving the overcharge or you're proving the pass-on, culpability isn't the key, therefore.
Yeah.
It is also not in any way qualifying the role of the Broad Acts. Yes, it allows attenuation, but it's not changing the basis on which proof is required on either side. Briefly, if I may, I'll then just touch on Gutman, which obviously two members of this court are very familiar with, so I'll deal with it very briefly. It's at tab 25, beginning at
Yeah.
Page 1447 is the start. I'll just pick it up at 1463, which is on the Microsoft test. So this is a certification test this court is dealing with. And
463.
yes, so I'm just picking up the heading there. So you've got the context. And then if we go on 2 pages to 1465, we've got observations on the Microsoft test. And just bearing in mind, obviously, here, as I say, what you're dealing with is the appeal against the certification of this boundary fares case. And what was being said was the expert methodology is just wholly inappropriate and doesn't found the basis for certification. And at paragraph 58 and 59, there are some observations made by my Lord Lord Justice Green in relation to the nature of the acts and its extendability or flexibility. And what's observed by the court there is one can be less demanding at the evidential, the expert assessment stage in relation to certification, knowing that later on down the line, practical justice can be achieved by the use of the broad acts. But the question we're asking ourselves in this case is, has the tribunal effectively expanded the head of the acts, whatever way one wants to talk about the metaphor, too far in relation to these issues? Yes, it can be used. Yes, it's a flexible tool, but it's not a tool of unlimited flexibility. And of course, in 59, what is said is that the acts can be used in relation to issues of liability. And again, we're not taking issue with that finding in the context of this appeal, but it is a useful thought experiment when one is thinking about the broad acts itself. The broad acts doesn't change the fact that you have to prove liability.
No.
It doesn't change the fact that you have to prove substantial loss in relation to quantum. Yes, it can be used with a degree of flexibility in both circumstances. We accept that. It's the degree to which it can be deployed and how it has been deployed in this case that is critical. And it's that I want to move on to now, if I may.
Right. So where are we going now?
The judgment.
Right.
So that's in the core bundle itself, and it's at tab 17, starting at page 148.
Yeah. In paragraph.
I think if we start at page 221167, that's the appropriate place to start.
Yeah.
So this is all under general principles of law.
There's no challenge to this, is there?
In relation to the general principles of law, I will come back to some of the observations made.
Well, there's no challenge as a matter of grounds of appeal
No,
to the tribunal's summary of the law.
no. What I will need to come back to is to touch on how it is the errors may be explicable by reference to what the way in which the tribunal's expressed itself here. But this is you're right. This is the only issue that is dealt with that touches on this is actually in relation to ground 2, in relation to issues of legal causation. But in relation to questions of the operation of the broad acts, this summary of the law isn't something that is a matter that is in itself problematic. So you've got that outline of the generality of the law. If we skip forward then to 326, which is the section on overcharge, page 282.
Yeah.
should say the references to the broad acts are at 173 and 174 in that earlier section. So 326, the start on the overcharge, and if we go on to paragraph 332, this is just picking up the point that I was making to my Lord Justice Newey earlier, that actually there was a consensus that, so this wasn't challenged by the appellant, that the effective way to assess the relationship between the two variables was using regression analysis, and that was the way in which it was appropriate to approach the question of what the quantum of loss would be in the counterfactual. And if you want a very simple outline of how the regression analysis works, if you turn back to 328, it explains how you take the dependent variable of the truck price and then you test using modelling, using the very extensive data that was provided, various other independent or explanatory variables. And what you're trying to do is identify whether a variable that sits as a proxy for an infringement effect is showing that there is a change in prices correlated with that particular variable rather than with other variables. And 332 is helpful because it also sets out three of the serious issues that can arise when you're carrying out this analysis. That you can lack data, you can have what's called multicollinearity. Now that is obviously a very snappy term, but what it actually means is something very important. What it means is that if you have two variables within the regression that move in the same way, you may not be able to identify any sort of correlation effect, and certainly no causative effect of one of those variables. And the reason that that really matters here is because that is precisely what we see as a problem in relation to exchange rates. There's also what's referred to as omitted variable bias. Now, what I'm going to do is I'm going to skip forward because there were various parameters that were assessed in trying to assess what the overcharge was. And key to all of this was the question about whether or not price changes that were being seen in trucks in the UK were being driven by the supposed infringement effect or by other effects. And in particular, the other effect that was of salient importance was changes in the exchange rate between the pound and the euro. And the reason that was particularly important was because a lot of the costs incurred by the appellant were incurred in euros, but all of the trucks that were being sold, the claimants, were sold in pounds. And it's worth just picking this up then at page 299 under the heading Currency and Exchange Rates.
Yeah.
You'll see at 373 is the data used in the expert's regression contained transaction values that occurred in a number of different currencies. Both were agreed that modelling had to be conducted in a single currency. Mr. Harvey decided to conduct his analysis in euros. And I'll focus on Mr. Harvey's analysis first and then come back to Professor Nevin's. But Professor Nevin did his in pounds. Both gave detailed reasons and conducted many sensitivities. And then if we go over the page 374, the complexity on exchange rate stems from the fact that the relevant transactions took place in the UK were in pounds, but DAF's costs were largely incurred in other currencies, as are its ultimate performance targets and commercial objectives. In the period from the introduction of the euro in 1999, the euro was the most important foreign currency affecting DAF's business. Before and during the early part of the infringement, a variety of other national currencies were potentially relevant, but the focus of the expert evidence was on the pound-euro exchange rate. Mr. Harvey dealt with this problem, so this is the claimant's expert, by converting all pound transactions into euros at the current rate. and by using these converted euro price observations as the dependent variable in his regression models. What that meant in practice was that the prices of trucks sold in pounds were converted by Mr. Harvey into euro prices using the exchange rate at that moment or around that moment within the week of when the truck was sold. And then,
As opposed to when the relevant cost was incurred, which could have been earlier.
there were a range of issues in relation to what exchange rates when they were fed in. Professor Neville used a different methodology. But let me just explain where the problem arises with Mr. Harvey's approach, because what I'm focused on is the fact that Mr. Harvey's approach had what's called an identification problem. In other words, because of the way in which he moved all the prices into euros, his methodology was effectively unable to identify an infringement effect. You see, 376, as noted above, the treatment of currency factors in the regression models was a critical issue because of the identification problem that arises when trying to disentangle exchange rates from cartel effects. This was notably the case at the start of the cartel period, when coincidentally the pound strengthened against the euro over the period from 96 to 98, from around £1 to £1.20 to more than £1.40. That trend continued through to 2000 when it reached 160. The problem this caused can be illustrated by considering an abstract illustration of how an exchange rate affects the two experts' approaches. Suppose the product sold in pounds in the UK but manufactured in euros in the Eurozone. If the transaction price for this product is £100 and the cost is €80, the profitability depends on the euro-pound exchange rate. If we assume that it's 1-to-1, the €80 cost translates to £80, so the profit margin is £20. Now suppose the pound strengthens against the euro overnight. If prices and costs remain unchanged in their own currencies, then under Mr. Harvey's approach of converting pound sales into euros, the £100 price, when translated into euros, would appear to increase to a level in excess of £100.
100 euros.
100 euros, I'm so sorry. However, the supplier's euro costs would remain unchanged, and therefore the profitability of the £100 sales price would suddenly be increased. In a regression model such as Mr. Harvey's that converted all prices into euros, this means that the stated price for this product would increase after the exchange rate appreciation, even though the euro costs are unchanged. From the supplier's perspective, the UK sale has thus become more profitable. If this exchange rate happened to coincide with the start of the cartel, then in Mr. Harvey's euro-denominated model, the increase in euro price will be picked up as a cartel effect, even if it's attributable to the possibly unrelated exchange rate movement. And then, however, when consideration is given to how a competitive market might respond to this exchange rate change, the picture becomes more nuanced. If all suppliers face similar euro costs, so if they do, one might expect a competitive response between them, as UK sales are now so much more attractive. To sell more of their product in the UK, they'll be expected to reduce their pound prices, and the competition between them might continue until the original profit margin is restored to the competitive level that applied prior to the exchange rate.
Where this all gets to, and this is all very interesting, you're descending to a level of detail that isn't really appropriate in this court. Where it all gets to is paragraph 410, which says, in effect, well, they're both right or wrong. It's more nuanced than either of them are giving credit for. And so we have to find some middle way. That's essentially what they're saying. Which is what they say in a number of other places in their judgments in saying that they're using the broad axe.
Yes, that's right.
So
But
what's wrong with 410?
Well, let me go back. Let me take you. I was going to take you through a little bit more of this, but I'll take you to 395. Because they described Mr. Harvey's approach as an extreme one. and they accepted that he effectively imposed a straitjacket on the approach. And if you see at 395, there was no evidence in relation to DAF's pricing in relation to exchange rate movements. There was also no evidence that this would happen in a counterfactual with competitive interaction. This is why we described Mr. Harvey's position as an extreme one. This is referring to the phenomenon of somehow these changes through the exchange rate being competed away. Mr. Harvey did not and could not introduce a standalone control variable for the market exchange rate in order to address the identification problem. He said that his model cannot control for the exchange rate because of the correlation between the exchange rate and the infringement. He therefore accepted that there are difficulties in distinguishing between the exchange rate and the infringement. Professor Never agreed that in the context of Mr. Harvey's model, it would be difficult to disentangle the exchange rate and the infringement because of the correlation between these variables. However, he said correctly that this is a problem of Mr. Harvey's own making. And actually, if you go over the page to the graph, the chart, you can see visually illustrated the problem. That the lower blue line is a costs in euros. The purplish solid line is the invoice price for trucks when you've converted them into euros using Mr. Harvey's direct exchange rate. And the dotted purple line is the pounds-euro exchange rate. And so what you have is a situation where the explanation of what is said to be the driving force of a large part of the overcharge calculation could simply be the exchange rate. And Mr. Harvey was forced to speculate that somehow actually this wasn't due to the exchange rate and actually these margins would change, but there wasn't evidence in relation to it. And so what the tribunals actually found, and this is why moving from a balance of probabilities test, recognising it's attenuated, but then shifting to this notion of a broad axe approach is problematic. Mr. Harvey did not show anywhere close to any sort of more likely than not that the impact here was actually due, on all of this data, on the agreed approach to deal with this, was actually due to the infringement. And that is the fundamental problem.
This is all, if you go to paragraph 477, which is where they reach their conclusions
Yes.
about this, their conclusion as to why a loss was suffered, that's not applying the broad axe at all. That's simply saying two things. One is it's saying, well, there's an a priori, if you like, what the point there is, the obvious inference from the fact that your clients engaged in this dangerous activity secretly for 14 years. So they thought they were going to make a lot of money out of it, and they did. In other words, they were overcharging. That's the point that's made there. And then the other point that's made is whatever criticisms were levelled at Mr. Harvey's approach, overall, they didn't think that you were justified in saying that the extreme, that's Professor Nevin's extreme or your extreme, that Mr. Harvey's evidence should be dismissed altogether. So those are the two reasons they give for concluding on a balance of probabilities that there was a loss. And then they go on to consider in 479, having reached that conclusion, we then have to place a value on the likely overcharge, and that's where they go into the broad axe.
Yes. So what they've said is
your whole hypothesis that their conclusion about why there was a loss was based on some nebulous broad axe approach, if I can put it that way, seemed to me to be misconceived, Mr. Pitt.
well, 477 is dealing with the question of whether or not there was a basis for saying there could be an overcharge here.
Well, for saying that there was a loss, in other words, there was an overcharge.
Yeah, but
Because by definition, if there was an overcharge, there was a loss.
But what it doesn't do, and what it could never do, is quantify that
Yeah,
loss.
but that's the point. The quantification of the loss is where the broad axe comes in.
Well,
That's what all the cases say.
Yeah, I agree, of course, that quantification can involve the broad axe. But going back to the proposition that we had from McGregor, you have to prove the amount.
So just trying to break it down a moment.
Yes.
Do you accept that the tribunal was entitled to find on the evidence that there was a loss?
Yes.
And then say you can't use the broad axe to find out what the level of loss was.
You can certainly use the broad axe in making the assessment of the loss, but you still have to prove that there was a substantial loss. And the evidence that was relied on in order to do that was the econometric evidence. And what I'm showing you is that the econometric evidence does not show a substantial loss.
Can I try and break it down a moment then? So the CAT was entitled to conclude that there was a loss.
Yes.
For the very same reasons it gave in relation to finding a loss, it was or was not entitled to find that the loss would have been sizable.
It was not entitled to reach the conclusion that the loss was sizable, because in reaching its conclusion at 477, as my lord indicated, what was referred to was the broad inference from the fact of the infringement, the fact of the infringement being an object infringement. Now that might be sufficient to show that you have some sort of loss here. That doesn't tell you what it is. It's an object case, you've got no findings of effect. Precisely the exercise we were engaged with in the trial was trying to assess what that loss was, if any. It's accepted that there was a loss, but what we say is that there is a gap in the tribunal's analysis between saying there is a loss and saying there is a very substantial loss.
Well, what they're saying in that sentence at 477 is that there was a loss because there was, as a result of the cartel, they succeeded, that's to say your clients and the other cartelists, succeeded in materially affecting transaction prices. So there's a loss, a sufficient loss that materially affects transaction prices. So what you're really doing is saying, how many angels can you get to dance on the head of a pin? In saying, was this a substantial loss or a materially affected loss?
No, it's not, with respect medieval theology,
Well, it
in
sounds like it,
circumstances where what you are asking is whether or not you actually have proof of the amount of loss, which is the basic proposition that has to be dealt with. And what essentially the tribunal did wrong here was it said, yes, we do see that there's a loss. At that point, we can essentially split the difference. We don't like Mr. Harvey's approach. We don't like Professor Nevin's approach. And in those circumstances, we're going to split the difference. This is the metaphor of the broad axe substituting for proper proof of a substantive loss. Because the driving force of the assessment, the basis on which the claimants came forward to say there was a substantive loss, was using the data that had been extensively provided and the econometric analysis. That econometric analysis, from Mr. Harvey, let's assume there was no Professor Nevin here. Mr. Harvey's analysis does not show, and the tribunal is not saying that it shows, because it's more likely than not that there was a cartel effect rather than a foreign exchange effect that gave rise to the changes in pricing. Those are the passages I've just been taking you to.
Yeah, but what they say in this second sentence, having considered all the evidence, sat through 2 months of trial, they say, further, whilst there are legitimate criticisms to be levelled of Mr. Harvey's estimates of the effect, particularly with regard to the exchange rates, which is the point you've been making,
Yes.
we also consider it is clear that these criticisms do not justify the extreme approach, that's your approach, your expert's approach, of dismissing all positive overcharge results. So that what that's saying is that to an extent we accept Mr. Harvey's evidence that there was a positive overcharge.
Yes. And
Why were they not entitled to assess the expert evidence on that basis, having sat through all that evidence?
because what I've just pointed you to is the fact that in relation to the key evidence, I was going to take you to global financial crisis, but just focusing on the exchange rates. The exchange rate evidence put forward by the claimant, by their expert, on the tribunal's own analysis, does not show that there was a cartel effect. Now, in those I'm so sorry.
476, we haven't really looked. In 476, they, in terms of the evidential or probative value of both experts, they say they provided useful insights.
Yes.
And it enabled them to reach a better informed view on the critical question of overcharge. So they don't reject either expert. They found problems with the analysis of both experts, but they did get an evidential platform from which to operate. You then go to 477, which we've seen, and 478. When you get down to 480, they come back to your position, which was 0% overcharge, which they've now rejected. There was something.
Yes.
They've got Mr. Harvey's claim that it was between 6.7 and 14.7, depending upon time frame and truck type.
Yes.
And they then move on to the differences between the two parties, and they plump for something lower than Mr. Harvey's range, which was 5%.
Yes.
What's wrong with that?
Well, essentially, if you were to ask you, because what I've been showing you in relation to their actual analysis of their evidence shows that they didn't make a finding that you could make out from Mr. Harvey's evidence that there was a cartel effect. But then,
I wonder if that's right. I'm reading 476.
because
476 is
477.
476.
And 478.
I understand what's being said in those paragraphs. What is being done here is that having identified in the earlier passages that the econometric analysis doesn't show that you've identified an effect, because they're applying this very broad axe, broad brush approach, they say, well, look, you didn't make it at we're not saying he's made out his case completely, but he's sort of made out his case a little bit. So we're going to take that into account because we can use a broad brush or a broad axe. And that is precisely the criticism that we're levelling at paragraph 476, 477, 478 and through, that they are substituting that sort of generalised approach for the systematic and proper approach to, did he actually prove that there was a cartel effect here?
Can I ask you about the last sentence of 477?
Yes.
That's the one where they say that they're not justified in adopting the extreme approach for dismissing all positive overcharge results. So in effect, they're saying there's still some value in what Mr. Harvey said. Is it your case that there was no basis for that view? That they should have taken the position, there was no option but to take the position that there was no value left in Mr. Harvey's evidence?
In relation to the exchange rate issue, which is what they're focused on here, the answer is yes, because...
No, it's not what they're focused on with respect.
sorry.
They're saying, notwithstanding the exchange rate issue, notwithstanding that, we consider there is merit in Mr. Harvey's approach. That's effectively what it's saying.
So in relation to the exchange rate, there isn't. In relation to the global financial crisis, they effectively
Well, in
conclude that
relation
it
to
isn't.
exchange rate, the conclusion they reach is at 410. And I asked you about 10 minutes ago whether you challenged that. You didn't answer, but what they're saying there is, well, we don't really accept either extreme.
I'm sorry, I thought I had answered that by reference.
I'm sorry, I wasn't being critical.
No.
I'm making
Let's
a
go
point.
to 410.
410
Yes.
is where they reach
Yeah.
the ultimate conclusion about exchange rate, which is more nuanced than you would have us believe, because they're not saying we reject entirely Mr. Harvey, or for that matter, we reject entirely Professor Nevin. But the true position lies somewhere between the two extremes.
Yeah, I understand that's what is said in 410. The point I'm making is that the reasoning and analysis that precedes it in relation to the actual consideration of the exchange rate issue and the global financial crisis issue mean that conclusion is not justified.
Meaning in effect that the only reasonable conclusion was that there was no value left to Mr. Harvey's evidence.
In relation to certainly those aspects, there is one aspect in relation to which I have to accept there was value left, which is in relation to emissions premium. Because in relation to that, there was a low positive correlation between emissions premia and prices identified. There was then a dispute between the parties as to how that was interpreted, and that was our case on that was rejected. So to that extent, Mr. Harvey's account is accepted, but in relation to the financial crisis and in relation to exchange rates, the reasoning of the tribunal itself is recognising those do not identify the overcharge. And in those circumstances, the answer to my Lord's question about 410 is you can't carry out the analysis and then say afterwards, well, he didn't cross the thresholds, but never mind, we'll give him some credit for these things.
It's the same point as I made to you about exchange rates at 410. At 439, they don't reject entirely Mr. Harvey's evidence.
439.
Yeah, they say we do not wholly reject it in relation to the global financial crisis.
Yes, they say that, but if you go back to the basis on which that's being said, it's not comprehensible what that actually means in practice. Because if you go to the global financial crisis element, what Mr. Harvey did was he said, well, during the global financial crisis, there was significant impact on demand, and therefore I'll essentially just remove those years from my analysis. And it's worth just picking that up at 420. The global financial crisis starts at 312. And it makes the obvious points at, page 312, paragraph 411. It makes the obvious point that demand can affect pricing. And that when demands change, your prices may change. So if demand increases, your prices will go up. But you've got to make sure you're controlling for that, because otherwise it might look like a cartel effect. And normally, demand controls within the modelling do that. But it was accepted, it was common ground that the global financial crisis had a very significant effect on demand. And at 416, Mr. Harvey said that effectively that the impact on demand was so great that he would remove from his analysis the 3 years covered by the global financial crisis.
I just need to put a marker down. That's just not a correct description of what Mr. Harvey's model did.
Well, it included dummies. I'm sorry, it's worth just going to 416. Mr. Harvey used dummy variables for each of the years 2008, 2009, 2010, which had the effect of taking those years out of account for the purpose of the measure of the overcharge.
Right.
Then if we go over the page, you'll see Mr. Harvey's approach. 420, Mr. Harvey's initial intuition was the standard demand controls would be sufficient for the GFC effect. It is concerning that this only emerged at the hearing while he was giving evidence on this area. He disclosed that for the first time that he originally ran his model with standard demand controls in place and arrived at an overcharge estimate of between 1% and 2%. That result wasn't referred to in his reports. He then decided that the demand shift during the GFC was so profound that his demand controls weren't adequate, so he made the ad hoc adjustment to his model to include the additional dummy variables that I've just referred to. In effect, this meant his model gave up any attempt to measure the effect of the cartel in this period, since the dummy variables for these years would be equally effective in capturing the GFC and the infringement effects during those years. So that's what the tribunal is saying. And then if we go down to 422, the adoption of those variables also crucially means that the options to assess the GFC effect separately from the end of the infringement is eliminated, creating a clear identification problem. Similarly, Mr. Harvey's GFC dummy variables also compromise the ability of the model to measure the impact of the sharp fall in the value of the pound against the euro in 2008. So there were a whole range of issues that were caused by the choices that the claimant's expert made in relation to his analysis here. Quite apart from the fact that he'd done an initial analysis that he didn't disclose using the same techniques as Professor Nevin. Those criticisms are picked up to some extent in 425, where there's a criticism of Mr. Harvey changing the goalpost. And 427, when the discussion about Mr. Harvey's concerns about the use of dummy variables. The fact that there are concerns with Mr. Harvey's GFC dummy variables doesn't rule out the possibility that standard down controls might be unreliable in capturing the abnormal effects of the GFC. So what's happened there is the tribunal said, look, you've got a fundamental identification problem because of the way you've approached it. But we do recognise that if you do other things, you might not come to a full solution. Now, if you're an investigating body, if you're a public inquiry, if you're a French investigating magistrate that does this sort of thing, perhaps these are the ways in which you go about it. That is not the way that a damages claim should be pursued, and a court or tribunal should assess a damages claim. Mr. Harvey did not make out his case here. The claimant did not make out its case here, either on exchange rates or in relation to the global financial crisis. Now, you are quite correct, my lord, that at 410 and at 476 and 478, this tribunal then says, well, yeah, but we'll give him some credit for it. It's somewhere in the middle. That is simply the wrong approach. That is the manifestation of this broad axe approach, removing the proper discipline on whether or not the claimant had proved their case in relation to substantial loss. And as I say, this isn't about precise numbers. This is that the tribunal's own analysis correctly said, you have not shown...
That's your submission. I have to say for myself, I don't accept that that's what the tribunal are engaged in here in any of the paragraphs we've shown you.
Well,
what they're engaged in is considering the criticisms they level against Mr. Harvey, which you had put very strenuously before them and you do before us. They also considered that Professor Nevin's approach was not appropriate for all sorts of reasons, including that they were concerned about his objectivity. And they said, we conclude that the true position lies somewhere between the two extremes. That wasn't actually applying the broad axe. They never mentioned the broad axe in any of that for 1 minute. The first time they mentioned the broad axe in this context is when they've found at 476 and 477 that there was a significant loss. They then go on to seek to quantify it by reference to the broad axe.
yeah. But the findings, the generalised findings at the end of each section to which your lordship's referring, so 410 and 476 and so on, are not justified by the analysis that has gone before if you are not using this loose broad axe approach. If you are actually applying a test that says, have you proved a substantial loss, that is not made out on the basis of the tribunal's own findings in relation to the methodologies used by Mr. Harvey in relation to both the global financial crisis and in particular the exchange rates, both of which have very substantial effects on any outturn. And if I could just go back to our skeleton argument, which is at page 66.
Just before that, can I just clarify, your final position is either that the tribunal should have accepted Mr. Nevin's analysis of a 0% overcharge, or should have held that it had not been established that there was an overcharge, ergo it's treated as 0, ergo the claim fails.
Well,
is that the end analysis?
I don't start with Professor Nevin. I haven't gone through the Professor Nevin material.
You simply say the standard of proof was not met.
We say the standard of proof was not met. The broad axe can't solve that problem because of the fundamental identification issues with Mr. Harvey's approach, which was the basis for substantial loss assertion. In those circumstances, it wasn't open for the tribunal to reach a conclusion that it could give some sort of value to these matters because it had not proved these things.
Bottom line, the claim fails.
The claim fails. I have given you the position in relation to emissions premium as well, fairly, in relation to that element.
Sorry, you're going to show us 2 paragraphs of your skeleton.
I was going to, if I may. I'm conscious my lord needs to leave.
Well, if you can do that in 4 minutes.
Yes, if I may, because there are 2 things. There may be one thing that I need to come back to after your chairman told us. But if I go to page 66, so it's tab 6 in the core bundle.
Yeah, page 60.
Page 66 in my
66, thank you.
Yeah.
66. Okay. Yes.
So from paragraph 35 through to 43, we explain how these fundamental methodological flaws in Mr. Harvey's models were actually being identified by the tribunal. But then at 44, we explain that by simply saying, okay, well, we'll give him some credit for this and we'll split the difference, the tribunal was effectively ignoring the burden of proof in relation to quantum and not directing its mind to whether or not there was proof of a substantial loss due to the infringement, and confused matters to do with causation and quantum. Furthermore, as we go on to paragraph 54, because it then used Mr. Harvey's evidence as some sort of legitimate benchmark to split the difference, when it had already found that in relation to these substantial components on exchange rate and global financial crisis, his approach did not show a loss. It was approaching this in the wrong way. There is a point I'll briefly come back to after the break, which is at paragraph 57, where there's a clear error interpretation of Mr. Nevin's evidence. In fact, I can just give you the references because they're in paragraph 59. One of the criticisms that's levelled in relation to the exchange rate analysis is, well, Mr. Harvey may have an identification problem, but you, Professor Nevin, didn't take into account exchange rates other than something called a budget rate, which was an internal rate by DAF. That was wrong. It was simply wrong on the part of the tribunal. And we've set out the material in paragraph 59 with reference to the supplementary bundles. I can take the court to that if that's necessary. And then the 61 onwards is you can't just have this Solomonic splitting of the baby, which is what effectively has gone on here. That is not applying a proper approach to the burden of proof here in circumstances where Mr. Harvey's numbers were flawed and shown to be fundamentally flawed because he couldn't identify cartel effect properly.
Okay. How are you doing, Mr. Bird?
I'm going to, I hope, just move on to ground two.
Good. Excellent.
I'll review over the short adjournment.
2 o'clock, please.
Great.
All rise.